Hi, my name is Lidia Casas. I'm a professor of law at the University Diego Portales in Santiago, Chile. Today we'll talk about women's rights and abortion. Abortion entails the possibility that women have control over their reproductive function. It is also one of the most contested legal and moral issues and one of the main public health concerns worldwide. In this lesson, we will talk about the legal regulation of abortion, the standing of the embryo, international human rights standards, the inter-American system, and the case of Chile. The legal regulation of abortion has an impact on women's health because when it is outlawed, it leads to unsafe abortion, resulting often in death and morbidity. The World Health Organization estimates that more than 22 million women worldwide undergo unsafe abortions and 5 million experience complications, causing more than 47,000 deaths annually. Most of these deaths take place in low and middle-income countries, such as those in Latin America and the Caribbean. WHO recommends the liberalization of laws since restrictions do not deter abortion, but they rather lead to clandestine practices. The three main models for the regulation of abortion are: it is permitted up to certain numbers of weeks of pregnancy. Others permit abortion exceptionally to protect the woman's life or health, when the pregnancy results from rape, when the fetus has a congenital malformation, or the woman does not have the means to support the child. A few countries ban abortion in all circumstances. Most European countries, Canada, the United States, Australia, and New Zealand, permit abortion on demand. So do Uruguay, Puerto Rico, Cuba, Guyana, and Mexico City. The rest of Mexico and some other countries have regimes that permit abortion under certain exceptions. The few countries that do not permit abortions are concentrated in Latin America and the Caribbean: El Salvador, Honduras, Nicaragua, the Dominican Republic, and Chile. In Europe, they are limited to Malta and the Vatican. In Ireland, abortion is legally banned, but the Supreme Court has declared that it is legal to perform an abortion when a woman's life is at risk. Yet, one thing is to have laws, and another is whether and how they are implemented. Most Latin American women have no access to a legal abortion, even if permitted. There are obstacles such as the absence of protocols and clinical guidelines when women need to access the services, or the widespread use of conscientious objection among healthcare providers. This last problem is widespread in Italy, where abortion is legal since 1978. In 2016, the European Social Council of Human Rights condemned Italy for the lack of access to procedure, thereby forcing women to go to private facilities, to travel abroad, or undergo unsafe abortions. One critical issue in international human rights law is the standing of the embryo or fetus. The same question it is also raised in many domestic jurisdictions. But even if it is assumed that there is a person from the moment of fertilization, the question from a legal point of view is not when the life begins, rather what protection is to be afforded to the life in gestation in light of women's human rights. The European Court of Human Rights has stated in its 2004 decision, Roe versus France, that it was not up to the court to define whether the unborn is a person, but it does not mean that prenatal life is not protected. A similar reasoning is found in the Inter-American Court decision on Artavia Murillo versus Costa Rica of 2012. The right to life in general, from conception, under the American Conventions is not an impediment for the legalization of abortion in the Americas. Although the International Human Rights Instrument do not refer to abortion as a right, all international human rights monitoring bodies have stated in general observations and country recommendations that the lack of access to legal abortion services means undermining women's human rights, such as the right to life, health, bodily integrity, and freedom of conscience. General Observation number 28 of the UN Human Rights Committee has declared that to report women to the police when they are in a hospital ward due to complications of an illegal abortion is a breach of medical confidentiality, amounting a violation of the right to privacy under the International Covenant on Civil and Political Rights. Moreover, it stated that restrictive abortion laws jeopardize the right to life, personal integrity, and security of women. In May 2016, the Committee on Social, Economic, and Cultural Rights issued a General Comment number 22, which reaffirmed that the denial of abortion services is a violation of the right to life and security, and in some circumstances it can amount to torture or cruel and inhuman and degrading treatment. As noted by the committee, states have an obligation to ensure women's rights and gender equality. This obligation includes providing sexual and reproductive health services, among other means, by liberalizing abortion laws. The committee added that a core obligation under the Covenant it is to repeal or eliminate laws, policies, and practices that criminalize, obstruct, or undermine access by individuals or a particular group to sexual and reproductive health facilities, services, goods, and information. Several complaints have been upheld against states for not fulfilling their obligation to protect a woman's life or health. In Yantoy versus Peru in 2005, later in MR versus Argentina, the Human Rights Committee held that the denial of a legal abortion for a rape victim inflicted physical and mental suffering, violating the woman's right to be free from torture, cruel, inhuman, or degrading treatment, and her right to privacy. The European Human Rights Court ruled in RR versus Poland that the state failed to provide a woman's information to make a considered decision about her pregnancy, and that this fact amounted to inhuman and degrading treatment and a violation to the right to respect her private life. Previously, the European Court also held Poland accountable in Tysiak versus Poland in 2007 for denying a woman an interruption of a pregnancy that deteriorated her health. The Inter-American System of Human Rights has dealt with abortion in several occasions. In the case of Paulina Ramirez versus Mexico, the state reached an amicable agreement for denying the girl to end a pregnancy that resulted from rape. The Inter-American Human Rights Court, in the case of Beatriz versus Nicaragua, issued precautionary measures so that the state protected the life and health of women that require an abortion due to her serious medical condition. Chile is making strides in the last 2 years to approve a regulation that would permit abortion under 3 grounds: to save the woman's life under imminent life risk, in case of a fetus with a malformation incompatible with life, and when the pregnancy is a result of rape. Opponents have used international human rights law to deny the possibility to legalize the interruption of a pregnancy, and deliberately have rejected any of the international human rights legal development on the relationship of women's human rights and the protection of prenatal life. This is certainly one of the major challenges that the international human rights community faces that undermine of long-established human rights standards. Thank you for watching this class. Please visit our website, mooc-chile.com, and we invite you to watch the following classes of this course. Have a nice day.